Bridget Mackay. I'm an attorney and I practice in Petaluma, California in the area of estate planning, trust administrations, probate, drafting trust wills. And this month I'm dedicating my video blogs to same-sex couples in honor of the up-and-coming Supreme Court decision. By the time you see this, the decision may be out, I don't know. But today's question is, as a same-sex couple, as registered domestic partners or a married couple, do we need separate trusts? So I'm focusing on folks who are married or have a registered domestic partnership and are interested in getting a living trust. And as you research this issue, I think, or at least I have heard, and I know out there, there's a lot of different advice about how to go about it. Some people recommend separate trusts, one for each spouse, and have them what we call mirroring, or where the terms of each spouse's trust reflect what the other spouse is doing, and they're sort of a cohesive unit. But I also think that there are arguments to be made that there are joint trusts needed. What distinguishes that advice? Some of the things that I think people think about is, what are the character of your assets? And when I say character of your assets, I mean how much community property do you have, and that's defined by any property you acquired during marriage or registration, or how much separate property you have, and that's all the property you would have acquired prior to registration and or marriage, and anything you might inherit individually. So there are obviously a lot more sort of nuances on that, where maybe a separate property house, but the work and mortgage was paid by the community, and I'm not going to go into those details, but that's sort of a broad brush stroke of what you're looking at. So we look at character of assets, and there is a conflict without the Supreme Court rendering a decision yet around federal rules and how tax treatment is done with same-sex couples. So if you're a high-wealth same-sex couple, you're going to have income tax issues, federal estate tax issues when you go about doing your estate planning, which may dictate whether you're going to have separate trusts or a joint trust. And a more soft issue that is taken into consideration when determining separate or joint trusts for same-sex couples is children. Are there joint children of the relationship? Or are there children that are prior to relationship, and what is the treatment of them going to be? I like to try and get joint trusts for any couples that have children together, just like any other couple out there that want to put a trust together and have children, because I think having it all in one place and not having several trusts dictating how children are being cared for financially gets confusing and complicated. So the bottom line is, same-sex couples out there, talk to an attorney who's knowledgeable in same-sex issues, tax issues, laws, federal versus California rules, and when you're putting an estate plan together. And don't just go to LegalZoom or someone that may not have that expertise.